Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to talk about a headline that lots of people had questions about because it's pretty odd. Lots of people are going, how can this be? So I want to go through it and then explain the law and talk about it. So first, let's have a look at the article itself just so that we know what's going on. So the headline is, Quebec Karate Tournament nixed after provincial lawyers realize it's against the law. It says, Karate Quebec announced Thursday that the Quebec Cup was postponed due to confusion in the interpretation and application of the criminal code that makes karate competitions illegal without a provincial decree. The weekend competition in Montreal was to be used as a selection event for the Canada Games. However, the sport no longer has an exemption under the code since karate is not on the Olympic program for the 2024 Paris Games, Karate Quebec said in a release Thursday. And I'll explain why that's relevant, because the law here is a bit weird. While practicing the sport is legal, I'm going to put a big old asterisk on that because we're going to look at the criminal code on this and talk about whether, in fact, practicing the sport is legal. There's wrinkles to that. The removal of the Olympic exception and a lack of a decree means a competition could expose organizers, stakeholders, and athletes involved in so-called prize fights to the risk of punishable offenses, the association said. And it goes on to talk about the impact on the various participants, which of course is huge because some people have been training their entire life for this. And, when you're involved in this kind of athletic pursuit, your sort of peak years might be just 1 year. Missing the year that you are at the best of your game might mean that you never get that opportunity to excel at those highest levels. So that's sort of a problem there. And they note negotiations continue, athletes train. Meanwhile, Rivest said that the sport is still a member of the Olympic movement and the Canadian Olympic Committee and is included in major multi-sport events outside of the Summer Games. And they were going to use this as a qualifier. They also note that the sport is essentially non-contact at the junior level with only a skin touch allowed. And so they were a little confused as to how this could count as prize fighting. And they note that at adult competitors, that they allow light contact, but you're never really going full force on people. This is not something where you're kicking people or punching people at full strength. All right, so that sort of gives us an idea of what's happening here. Again, I'm going to link the article below if you want to read the full thing, and I recommend that you do. But let's have a look at what the criminal code has to say, because this is a bit of an unusual section. It's one that not a lot of people think about, and I'm not sure that they necessarily interpreted it correctly. But I'll have some comments on this law as we go. So prize fights, section 83 sub 1, which is kind of funny because section 83 otherwise goes on to talk about terrorism. So they kind of rolled that in there. Now, the numbering doesn't mean that they think that prize fights are terrorism. Basically, it just means that they wanted to amend the criminal code and wedge a bunch of stuff in there. And that as they did that, they found a place where there was sort of number room. So don't read too much into that. I just think it's kind of interesting. So everyone who A, engages as a principal in a prize fight, B, advises, encourages, or promotes a prize fight, or C, is present at a prize fight as an aide, second, surgeon, umpire, backer, or reporter, is guilty of an offense punishable on summary conviction. So this is one of the few summary conviction only offenses that we have in the criminal code, which tells you that this is probably not the most serious, because even like stealing a bottle of liquor from the liquor store is something that they can proceed either summarily or by indictment. There's not a whole lot of summary conviction only offenses in the criminal code. I actually think that's its own problem, but yeah, slowly they've been rolling things into summary or indictable. Now you might be saying, okay, what's a prize fight? What kind of prize has to be at stake? Well, they've got a definition, and definitions are always important. In this section, prize fight means an encounter or fight with fists, hands, or feet between two persons who have met for that purpose by a previous arrangement made by or for them, but does not include. This is really broad, and notwithstanding the fact that they call it a prize fight, you don't actually have to have a prize on the line. There doesn't need to be a trophy. There doesn't need to be a purse. Just any encounter or fight. Now, this is kind of interesting because normally you can consensually get into a fight. However, because of the prize fighting rules, you can't consensually get into a fight if you planned it ahead of time, unless you fall into one of the following exceptions. So when you see people online saying, hey, meet me on Friday at this place and we're going to fight, they might be running afoul of this. The classic thing that you see in, shows and movies about, schools, like, meet me in the bleachers, behind the bleachers on Friday and we'll sort this out. That might be a prize fight. So I think that's a little unusual. Okay. Definition of prize fight. In the section, so I already read that bit, so there's exceptions here. So things that it doesn't include. A contest between amateur athletes in a combative sport with fists, hands, or feet held in a province if the sport is on the program of the International Olympic Committee or the International Paralympic Committee, and in the case where the province's lieutenant governor and council or any other person or body specified by him or her requires it, the contest is held with their permission. So this is what karate used to be relying on. They used to be saying, listen, we're on the Olympic program, so we fall under the exception in 83-2A. So we're good. Which is great until your sport gets dropped by the Olympics, and then suddenly you go from legitimate activity to maybe criminal offense. And that's kind of concerning. However, you saw that they're still in negotiations, and clearly those negotiations aren't put karate back in the Olympics for 2024 because the IOC doesn't care. They're not going to reach out to just help Canadian, athletes here. So there's other exceptions here. B, the contest between amateur athletes in a combative sport with fists, hands, or feet held in a province if the sport has been designated by the province's lieutenant governor and council or by any other person or body specified by him or her, and in the case where the lieutenant governor and council or other specified person or body requires it, the contest is held with their permission. So this one is a little more flexible and allows for a sort of designation. Or C, a contest between amateur athletes in a combative sport with fists, hands, or feet held in a province with the permission of the province's lieutenant governor and council, or any other person or body specified by him or her. And D, a boxing contest or mixed martial arts contest held in a province with the permission or under the authority of an athletic board, commission, or similar body established by or under the authority of the province's legislature for the control of sport within the province. All right. So there's various other ways that you can, get included in this. And I will note that this was updated fairly recently in terms of legislation. And recent, in this case, means 2013. They actually updated this, which is why you see the reference to mixed martial arts, because that wasn't really something people thought about. And then suddenly mixed martial arts was taking the world by storm. It's become hugely popular from basically nothing within not too long. And so they amended it to allow for mixed martial arts. Now the question really becomes, is this necessary? Because it's very rare that people actually get charged for this. And this is, I think, a little bit interesting in that it's actually one of the few bits of legislation that seems to specifically call out media. Like, by being there as a reporter, you commit a crime. Which is weird, because normally I would think that a reporter showing up to record something that might be newsworthy, hey, people are engaging in criminal activity at this time. We sent an undercover reporter to get information on that. That might be something really kind of useful to know. That might be of public interest, but nope, we ban reporters from being present. That's kind of odd. That's kind of unusual. But we already have laws that regulate sort of what you can and can't do in a fight. So I already, in a previous video, I'll see if I can link it here, covered the case of Jobidon. And Jobidon indicates that you can't go into a fight and sort of intentionally cause people serious injuries. There's limits to how badly you can injure people. And those limits are actually kind of raised for things like hockey and, boxing and so forth. But do we really need this prize fighting thing? And the other thing I'll mention here is that they were talking about, hey, um, this is actually legal. It's legal to practice karate. Well, yes and no, because it could actually fall into a category of legally interesting, which is generally somewhere you don't want to be. Interesting in law means expensive, and it's debatable because sure, practicing a punch or a kick, no problem. But what if you're sparring? Because at that point, you are in having an encounter with fists, hands, or feet between two persons, and you probably didn't just kind of spontaneously decide to spar. It might be, hey, next week we're doing sparring, so come on down, be ready for that. And right at that point, it was made by previous arrangement, made by or for them. For them can mean if it was made by, say, the coach or the person teaching karate. I'm not sure what the proper term is for a karate sensei, I guess. I hope. So I think this is a bad law. I think this is an unnecessary law, and you can see it sort of rearing its head here when you've got this change that suddenly requires everybody to scramble for an exception. What happens if you're developing some sort of new combative sport? How do you get a new sport? And I mean, new sports come up all the time. Like basketball is a fairly recent invention in terms of, historical times in sports. Um, we shouldn't need to amend the criminal code each time somebody develops a new sort of combative sport. I am not a super fan of this one overall. I think that the proper way to do this is ultimately just to eliminate this section entirely. And to the extent that we need some sort of regulation for it, first, we've already got criminal provisions that deal with fights that, hurt or injure people. So you're not going to get a whole lot of like back alley, like really injurious boxing. But what does it matter if people set up their own sort of sports, so long as those sports are dealt with in a fashion that is sort of responsible and limits injury? And to the extent that it does require regulation, why is this in the criminal code? Why isn't this passed on to the provinces who would normally have sort of regulation of sort of just kind of ordinary rules of how you go about business and this kind of thing? So that seems like something that shouldn't be a criminal offense, but maybe should be a regulatory offense within provinces if we need something at all. So lots of people wanted me to explain this one and sort of like, how could this be a thing? Well, it's because the criminal code includes this weird provision. And, if you want to know just sort of how old this is, how long this has been there, I went looking for case law on this, and I found a case, Rex v. Pelkey from 1913. So this is from the Court of King's Bench, and this isn't like King's Bench because we just recently renamed it with the passing of the Queen. This is King's Bench because it predates Queen Elizabeth II. It's a case from 1913 talking about prize fights. I'm not going to go through it because it's not super relevant to this case, but this one just seems like something that we could just get rid of from the criminal code entirely. So hopefully that explains what's happening here, why Canada has banned this. This also, of course, means that there's a wide range of sort of combative sports or martial arts that are potentially banned in terms of what kind of practice you can do and what kind of competitions you can have. I feel like it shouldn't be this case that every single kind of combative sport needs to necessarily ask for permission, but that's where we are. The other thing that is kind of weird about this one is that it specifies fists, hands, or feet. So if you have a combative sport that doesn't involve those things, then it's not captured. So for instance, kendo, which is practicing nominally to use katanas, although in kendo practice it's generally a wooden sort of bamboo stick that's intended that you can strike people who are wearing the armor without causing them injury. But I mean, you can get hit pretty hard in kendo, but because you're not punching people or kicking people, you're hitting them with a stick. Doesn't seem like it's included in that. That feels weird, right? Where you can have a sort of a punching sport, but not, sort of, and fencing wouldn't be included, notwithstanding the fact that it's a combative sport and that it might involve harder touches, harder contact than it sounds like the junior karate does. Because if it's only a skin touch, well, you can tag people a lot harder in fencing than that. So I don't think that there's really a principled basis for this. I don't think it makes a whole lot of sense. Yeah, that's kind of my thoughts. Let me know what you think in the comments below. Do you think that this is something that is useful? I I really think that it would be worthwhile to have a project to get sort of a bunch of designated naysayers, a bunch of people who just their job is to go through and be sort of obstinate about things and go through the criminal code and say this part not all that useful, and try to see how much stuff we can just weed out as not useful anymore in the modern age. I mean, they got rid of provisions about witchcraft, but we still have this stuff on prize fighting. It seems to me there's a lot of stuff in the criminal code that maybe isn't super necessary. Sure, we should absolutely be keeping stuff like, theft and murder and, so forth, but there's a lot of weird stuff that maybe could go. Anyway, thank you for watching. I hope you found this to be interesting or educational. Please like this video, share it with your friends, subscribe to see more content. Leave a comment. That's also helpful. I also want to thank my Patreon supporters. There's a link to the Patreon in the description below. It's a way that you can provide sort of direct support. And I get a bigger cut out of Patreon or locals than I do from YouTube. So those are sort of more efficient ways of giving, if that makes sense. But at the $50 level, the CCFR, Canada's National Firearms Association, and the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited. And at the $20 level, Mark, Jane Baben Luxor, Haywire, Dale Nesbitt, Cameron Johnson, Andrew Elsich, Vicky. Thank you as well to all of the $10 supporters who will be in the crawl immediately following. Thank you for watching. I hope this has armed you with knowledge. See you next time.